Welcome. Our session is called Water Rights, Markets, and the Environment. I'm David Theroux. I'm the president of the Independent Institute, and I'm delighted to be chairing the session with a very distinguished panel of scholars. The focus of our panel is water facing a crisis? And the answers are yes and no. On the one hand, declining water quality is a serious problem in many parts of the world, not the least of which is the Western United States. And if recent usage trends continue, shortages are inevitable. On the other hand, water quality has improved in many economically advanced countries, and in some regions, institutions and policies have been adopted that would postpone or even avoid the onset of water crises. The book that we're in particular focusing on is a book called Aquanomics, which is edited by one of our panelists, Randy Simmons, with a colleague at Brigham Young whose name is Gardner. And we hope that you get a chance to take a look at it. You have information about that book as well. So the format for our panel is we have 4 presenters, and I will introduce each one sequentially as I proceed. The first of our speakers is Randy Simmons, who's professor of political economy in the Huffman School of Business at Utah State University.
Well, thank you. The question about is there a water problem, as David said, it's both yes and no. If we would allow markets to work more effectively, there would be no problem. But talk a bit about why it is that politicians prefer ribbon cuttings to brooms. It's a line I learned from Randall O'Toole. They prefer to be able to cut ribbons at grand openings of things, as opposed to the sort of sweeping up needs to be done to make things work. And so that's what often happens, especially with water. I think Brian's going to talk a bit about that. So this is a snake valley right on the Utah-Idaho border. It's really dry. There are a few seeps like this one in the picture, but what's amazing about this place is that underneath all of that dryness is a huge aquifer. I assume left over from the ancient Lake Bonneville, but it's this huge aquifer, and Las Vegas wants it. And the folks, there are people who live in Snake Valley who are just so opposed to having anything happen. They say, well, this is a long-standing community, maybe 200 people. They might need the water for future development. Well, you saw the picture. And they claim, well, Las Vegas is simply looking for cheap water. Yes, Las Vegas is looking for cheap water. They're looking for water as cheaply as they can get it. And then they say, well, there's just not enough water. So a pro-market perspective on this issue is that, well, markets provide signals about the value of resources. A long history just doesn't mean that it has to stay that way. Things can change. Markets respect future values as well as current values. They help us to actually see to the future, especially if we have any entrepreneurial vision. Now look at the difference in the price. Water in Snake Valley that you pump out of that aquifer for irrigation sells for about $100 an acre foot. That same water in Las Vegas is worth $4,000 an acre foot. Now you would think that would things would move relatively easily, wouldn't you? But there aren't really clear, well-defined property rights to that water. And so judges are used to say, hey, you really don't have a right to sell that water. So the question is, if it were clear who owned it, it would be easy to see to have a market work, but it's not clear. So what we end up with is, we have some, in pure terms, we can have an economics approach to moving water, moving it to its most highly valued use, or we can have a political approach. Now, I was mayor of a small town in Utah that wanted more water. Notice I didn't say needed, wanted more water. And it took us, we moved a water right 15 miles. And it took nearly 2 years and 3 court cases to have that happen. So luckily, given my perspective on why we wanted the water, it moved for the right reasons. But the cool thing about Western water law in general is that we have this prior appropriation doctrine that says first in time, first in right. If you were the first person to divert water, you're the one that gets it. So this is the Blacksmith Fork, or Providence Blacksmith Fork Canal diversion on the Blacksmith Fork River. This is the stream, one of the irrigation streams that comes into the town where I live and where I was mayor. Pioneers showed up in 1859. By the fall of 1860, water was flowing in this canal. By the next spring, there were something like 400 acres under irrigation. So what happened is that those of us who have shares in this water company own the right to divert that water. It's really clear. If we want to sell to somebody else in our canal, we can do that. It's really easy to transfer water. The problem is that you can get a situation like this. This is from Montana, picture that Terry Anderson had. On the day that this irrigation was all happening, and there was so much water being put that it's, in the borrow pits alongside the road, the water's standing. Well, the Ruby River, where the water was coming from, was drying up and fish were dying. So Terry's line is, let's give those fish a drink. But the question, if the water rights are clear and it's actually clear that you can sell them, you can fix problems like that relatively easily. Here's a picture of an example. This is what's known as a push-up dam. An irrigation company has the right to divert this water. They drive a D9 cat for 15 miles up the riverbed. They get to the point of diversion, they drop the blade and push up the gravel and end up taking all the water out of that portion of the Bear River where it's, and so none flows downstream. So there's at least a 15-mile stretch where there's no water. It's been what's called dewatered. And so Trout Unlimited came to this irrigation company and said, can't you leave some more water? And they said, well, we don't really want to. But they said, but the fish need it. And they said, well, so do our crops. And a bunch of other streams come in further down so that the river flows again. But what Trout Unlimited was able to do was they found, actually Coca-Cola put up a whole bunch of money that they were supposed to be, they claimed they were spending to provide clean water. And they changed the diversion point 15 miles downstream. So this water comes down. Now there's a whole new structure that diverts the water for the water company around a hill and over into their existing structures. Notice it didn't take the state. It didn't take state legislators saying you have to do this. It just took the guy from Trout Unlimited. It took him about 3 years of sitting in people's living rooms saying, here's what we'd like to do. Can you get on board with this? And seriously, it took him about that long. And when we went out there, the attorney from Trout Unlimited was with us, and I said, well, this is pretty cool. You got this whole voluntary transaction going on, and you have water for fish, and you still have water for crops. I said, is this an example of free market environmentalism? He said, I don't know what that is. This is just environmentalism that works, which is one of the better lines I think I've ever heard. We can think about water markets as they're being too kind. There are the voluntary arrangements, just like Trout Unlimited did. And then there are ones that are markets that the government creates. These are, I think, far better than not having anything, but they are created. You can have wetland mitigation banks, water quality banks, habitat conservation banks, ecosystem services. These are all systems that exist because governments say, hey, let's do this. This is an example of mitigation banking on Odell Creek it's west of Bozeman, Montana. On the left side, that is a notice how straight that stream is? That's a stream that was channelized by the Department of Agriculture in the 1950s. And notice how deep it is. It's just sucking all the groundwater out and turned all that land above that used to be wetland into grazing land. The farmers thought it was pretty great. The government paid to do it. But now the question is, they want to restore it and actually have it be the kind of wetland that it was, to provide the sort of habitat for fish, especially for spawning, for getting into this flows into the Madison. So the power company, whose name changes constantly, I don't know who they are anymore, Dominion, Rocky Mountain, anyway, they're running new power lines, and anytime they cross a wetland, under federal rules, they have to mitigate the fact that they've taken some wetlands. So they've mitigated they've given a whole bunch of money to the owner of this property, and he's turned this into an amazing wetland. So all of that was just that dry stuff. And he's thrilled about it. The power company probably would have spent their money on something else, but they had to spend it in this way. So this is one of those created markets. Another example of a created market is in the Pamlico River Basin in North Carolina. The cities along through there were having their sewer plants were just getting overrun. Population's growing, they needed to expand the plants. It is really expensive. But most of the problem was from pig farms further upstream. And so what they were allowed by the EPA to go negotiate with those farmers, and they paid to put in structures to keep the pig waste out of the stream, and it was far, far cheaper than it would have been if they had to just expand their sewer plants. So notice this little sort of market working there, but it's a market working within the government system. There are some problems that happen in these markets. For example, I gave you the example of us moving a water right 15 miles. There are so many people who can get standing in court these days to block such a thing that it becomes almost an anti-commons, where you got to get almost everybody to sign off, or you have to end up in court forcing them to sign off, and it can take a really long time. Then the question is, well, let's measure what's going on here. How are we going to measure if the water really is moving to where it's supposed to be? And when you have government creating markets, is it a good way to create a market? Is it a bad way to create a market? And then how about adjudicating whether or not there really are rights? And then there's the question of political predictability. Are the politicians who are allowing this to happen this year going to allow it to continue next year? So here's a really nice example of a monitoring measurement issue. This is a stream that is in Oregon. And I think it's the Oregon Water Trust contracted with a farmer to leave water in the stream rather than taking it all. And they go out and they measure that the water really is there, that it's actually happening the way they had organized it. So what they do is after this farmer stops taking water after about July 20. And so all of his water stays in the stream. There's plenty until about then when things really start to dry up. But what it means is he misses a third crop of hay. And so what the Oregon Water Trust has done is simply buy him hay. So he still gets the hay, the fish get the water. It's measured and monitored by the trust so that we know it actually happens well. The political predictability one will end with a slide of Harry Reid, since we are in Nevada, and he has been senator here for so long. I was betting that the Snake Valley water was going to come to Las Vegas as a pure political decision, because Harry Reid was the majority leader in the Senate, and the Democrats controlled the Senate, and we had a Democratic president. And I was just sure that they were just going to be able to force that to happen. I mean, I think it ought to happen, probably. If we let the markets work, it really ought to happen. But Harry Reid's no longer in the Senate. And so the chances of it happening the way they wanted is unlikely. But what we are getting is things like this on Odell Creek, where that's a system that is working. There are clear property rights functioning. They don't have to have Harry Reid intervene or any other politician intervene to make it happen. And so back to this on the Bear River. Is this an example of free market environmentalism? I don't know, but it's environmentalism that works. It works because there are clear property rights and because people are allowed to have voluntary transactions. Thank you.
Thank you, Randy. Our second speaker is James Huffman. Jim is Dean Emeritus and the Erskine Woods Senior Professor of Law at Lewis and Clark Law School.
Thanks, David. I'm going to pick up really where Randy left off on the question of the having clear and secure property rights and why in water law that often is not the case. There are several, I think, sources of contingency with respect to water rights, some of which we can't do anything about. The amount of water that happens to come out of the sky and the amount of snowpack we get. We can do things about that in the way of infrastructure and storage and so forth, and some of what we've done makes sense, and some of what we've done does not make sense because it's been heavily subsidized. But that's a contingency that is inherent in the water business. But turning to the legal contingencies, there is the police power, of course, which is the power of the state to regulate in the public interest, most broadly stated. And that leaves a certain level of uncertainty for property owners as to whether or not a particular proposed regulation is going to be a valid exercise of the police power, or more pointedly, whether or not a valid exercise of the police power results in the taking of a private property right. And I won't talk about takings law except to say that takings law is not favorable to property owners and hasn't been for decades, although we've had occasional cases in the Supreme Court making us feel like there might be some hope and then dashing our hopes. In addition to the police power, there of course are federal powers pursuant to the Commerce Clause and the navigation servitude which allows the federal government to regulate the use of navigable, in fact, waterways for the purposes of supporting navigation, which really derives from the Commerce Clause. And the Commerce Clause, as you may know if you know anything about the Constitution, has been incredibly broadly interpreted so that all kinds and all manner of federal regulation, including the Endangered Species Act, the Clean Water Act, the Marine Fisheries, National Marine Fisheries and Mammals Act, et cetera, all these are done and put contingencies, uncertainties there for property owners. But I want to focus largely on another source of uncertainty, and that is what Justice Scalia in the Lucas case, Lucas against South Carolina Coastal Council, referred to as background principles of property law. And background principles of property law are those things that any good property lawyer understands are constraints on property rights that have existed from time immemorial. They are rooted in the common law by and large. And so when I buy a piece of property and I'm told that I have a right to exclude anybody from that piece of property and to use it for whatever I choose, I really don't, because there are these background principles that say, well, I can't use it in a way that damages my neighbor's property. That would be a private nuisance. And that's inherent. That's one of the background principles of property law that Justice Scalia was referring to. And so his point in Lucas was, if there's a background principle that says that you can't do something with your property, when the government adopts a regulation enforcing that, they're not taking anything from you because you never had it in the first place. The background principles defined what you had in the first place. Well, my principal focus then, I want to talk about is one of those background principles, which is really one of two that environmentalists are using aggressively to try to constrain property rights in the interest of environmental protection. Nuisance is one, public nuisance is one, and there have been a lot of cases filed on that subject, and I won't talk much about that, except to say that if you track the case law, there are a lot of public nuisance cases ongoing, many of them in the context of climate change and global warming. The other one, and I think the most both powerful from the environmental point of view, environmentalist point of view, and the one that is sort of offers the most latitude in the minds of judges to expand the background principles that limit property rights is the public trust doctrine. The public trust doctrine is a doctrine that almost anything you read about it will tell you it came from Justinian, who said in the Justinian's Institutes, quote, "Things common to mankind by the law of nature are the air, running water, the sea, and consequently the shores of the sea. No man, therefore, is prohibited from approaching any part of the seashore." And that language is interpreted very broadly by all kinds of lawyers in court today, and mostly by academic lawyers who are engaged in my part of the business, who say, well, Justinian said air, therefore Mary Woods, University of Oregon, says there's an atmospheric trust doctrine, which says that you and I can't do things to the air, nor can the government, that affects our public right to be free of climate change. That's her argument, and I'll elaborate a little bit on that in a second. Well, the reality is, I've written extensively on the history of the public trust doctrine, that this quote from the Roman law of Justinian really has nothing to do with the public trust doctrine that arose in Anglo-American common law. Nor does Magna Carta, although it's often cited as a source of the doctrine. The doctrine, which I think did exist in Roman law and did exist through much of English law, was that there is a public right to navigate, largely for commercial purposes, and to fish in navigable waters. In England, that meant tidal waters. That was the way we defined what waters were affected by the public trust doctrine, which is to say, waters in which you and I have a right to navigate and fish. It doesn't mean that somebody can't own the underlying land, although modern-day environmentalists like to claim that the public trust doctrine prevents the state from alienating public lands. That's not true. And the evidence is everywhere, because almost every city in this country on the seashore is built on filled land, which couldn't have been done if you couldn't alienate that land. But in any event, the public trust doctrine, as it developed in late English law and early American law, was that and nothing more: navigation and fishing on navigable streams. The one change that happened between English law and U.S. law, English law, as I said, defined navigable waters as tidal waters, T-I-D-A-L, and in the United States it was quickly determined by the courts and recognized by the courts that we have these massive navigable waterways all over this continent, and that logic says that the doctrine ought to apply there as well. That was the one major change from English to American law. Well, in American law, the case law is pretty thin. There were some oyster cases in New Jersey in the early part of the 19th century, disputes about who had a right to exploit oyster beds in the tidal waters in New Jersey. And a case in the Supreme Court of New Jersey in 1821 held that there was very broad, it really held that the state could not alienate those tidal lands because it had granted an exclusive right to a particular person. Well, the law all around the Supreme Court of New Jersey at the time was to the contrary. There were statutes adopted by the New Jersey legislature authorizing the alienation of land, of waters for oystering, and there were all kinds of exclusive private oyster beds all over the shoreline. So the Supreme Court of New Jersey was just whistling in the wind, although that opinion, as often happens, was quickly picked up by other courts, including the United States Supreme Court in an 1840s decision, which ironically involved two disputes by private claimants to oyster beds, and yet the court spoke about public rights and the inability of the state to alienate. Well, the big case, well, let me then say that in 1969, Joe Sachs, a professor then at Michigan and later at Berkeley, wrote an article about the public trust doctrine. He kind of rediscovered it. Nobody was paying any attention to it. And he rediscovered it, said, here's a great opportunity for environmental objectives to be achieved in the name of the public trust doctrine. Nothing much happened. 11 years later, he wrote another article, the title of which was something to the effect of breaking the historical shackles of the public trust doctrine, which was really a recognition that the law was not doing what he wanted it to do because that wasn't the law. And so he was advocating that courts needed to become more creative and change the law. Well, some courts have done so. And I'll just give you a couple of examples in the limited time. In 1972, there was a Wisconsin Supreme Court case called Just against Marinette County, where the property owner had wetlands that he had wished to develop, and in fact had developed some of them. They adopted a zoning in the state of Wisconsin that prohibited that on wetlands. He challenged, said it was a taking of his private property, and the Supreme Court of Wisconsin said no. The public trust doctrine protected those waters because they were tributary to navigable waters. Interestingly, much more recently, the Wisconsin Supreme Court has really effectively overruled that decision by saying, no, it wasn't the public trust doctrine. It was the police power that authorized the adoption of those land use regulations. That's a case that, of course, the environmentalists ignore. Two others I'll mention. One called Mono Lake, California case. The city of Los Angeles was drawing water out of tributaries to Mono Lake, which is a what do you call a lake that doesn't have an outlet? Anyway, it doesn't have an outlet, so it's salt water, and City of Los Angeles was withdrawing water at a rate faster than the tributaries were filling it, so the level of Mono Lake went down. There was an island in Mono Lake on which there was breeding of some particular endangered bird. When the lake level got low enough, that became no longer an island, but a peninsula, which allowed predators to go in and eat the birds. And the Sierra Club challenged that, and the California Supreme Court said, the public trust doctrine prohibits the city of Los Angeles from withdrawing water because this is a navigable body of water. What was unusual about it was it didn't fit into the traditional public trust theory because we weren't talking about navigation. Nobody was going anywhere on this saltwater lake. And so they really rooted it in ecological protection, which was a pretty big expansion of the doctrine. A second case I'll mention is called Montana Coalition against Curran, and there was a second one, Montana Coalition for Stream Access against Hildreth. And what happened in those cases was, this is Montana, the Supreme Court of Montana said, not only is there a right to fish and navigate, but also to recreate, and we're going to define navigable waters not as navigable in fact, but as waters that can be used for recreation, which is almost every drop of water in the state. So let me conclude by sort of painting a brief picture of what the future might hold. There's a professor at the University of Oregon named Mary Wood, who's propounded, has written a book about it, written several articles about what she calls the atmospheric trust doctrine. And she argues that there is a right that you and I have to a climate that is not changing, and the real power of it is twofold. If she succeeds, and she's got a federal district court judge in Oregon who has allowed the case to go forward. Should have been dismissed for lack of a legitimate claim. It wasn't, and the judge articulated a fair amount that's really tipped her hand, and I think ultimately she'll rule in their favor. But the power of it is twofold, and therefore very threatening to property rights. One is if a court finds that the public trust doctrine exists in that context or any other context, it is a preemption of the takings clause, because by definition, if the public trust right exists, it's existed from time immemorial. So it predates any property right and avoids any takings claim. The second, and even more worrisome thing about it to me, is that courts will then be in a position to mandate that government take action that they may have chosen not to take. That is, if the part of their claim is the government needs to do something about climate change. Well, what is a court going to issue but an order to do something? But do what? That's not the kind of orders courts give. They have to be very specific. And there has been a case decided by a lower court in Holland that's done exactly that. Said to the Dutch government, and the Dutch government had adopted a fairly aggressive climate change policy. And the court said, that's not enough, you need to do more, so go do more. if our courts get into that business, they're not courts any longer, they're policymakers, and there could be no bigger threat, I think, to property rights. Thanks.
Thank you very much, Jim. Our third speaker is Lawrence McQuillan. Lawrence is Senior Fellow and Director of the Center on Entrepreneurial Innovation at the Independent Institute.
Thank you, David. Good afternoon, everybody. I'm going to talk about California, which I live and work in Oakland. And so, as you can imagine, California has probably the most regulated water markets in America, I would suspect. So I'm going to start out by talking about broadly the regulations and the regulatory agencies that deal with California water. So, for example, the California State Water Resources Control Board oversees water rights permitting and curtailment. There's 9 regional water quality control boards that set water quality standards, issue discharge permits, and enforce regulations. The California Department of Water Resources focuses on water delivery and infrastructure. It oversees the State Water Project, for example. The California Water Commission reviews Department of Water Resources regulation and water project operations. I'm not done yet. The California Delta Conservancy implements projects that benefit the Sacramento-San Joaquin River Delta, which is kind of the main water hub in California. The California Energy Commission sets water efficiency standards for appliances, and that's just the state government. Now on to the federal government. The U.S. Bureau of Reclamation develops and operates major California water projects, dams, power plants, canals. They operate the Central Valley Project, which is the main water distribution project for farmers, basically, in California. The U.S. Fish and Wildlife Service and the California Department of Fish and Wildlife enforce Endangered Species Acts and manage fisheries. The U.S. Environmental Protection Agency sets federal water quality standards, and I'm still not done yet. The daily responsibility of supplying water and sewer services to communities falls on thousands of regional and local water districts or water agencies. These water districts can provide services, for example, irrigation, drainage, diversion, storage, distribution of water to farms and urban areas. And there's like about 108 investor-owned water utilities. So these are like privately run and owned water agencies. And of course, they're regulated by the California Public Utilities Commission because they're investor-owned and not considered public utilities. So they have to be, or they are considered public utilities, so they have to be regulated by the CPUC, as we call it there. So, I mean, as you can see, it's a multi-headed water monster, which I call in the book that I'm currently writing, California Water Policy, that regulates California water. And as you can imagine, I mean, it's very difficult then to do any kind of innovation in this type of heavily regulated environment. The number of permits and authorizations, and of course, all of these agencies will go to court and fight it, whatever you're trying to do. So it's, you know, close to nearly impossible to get things done quickly, if at all. For example, in 2014, so this is 4 years ago, not that the state should be involved in more heavily in water, but California voters approved a water bond, and part of that money, it was $7.5 billion water bond, and part of that money was to be used for water storage, additional new water storage in California. And so 4 years now after the fact, not only has no new water storage come online, but every proposal to create new water storage in California thus far has been killed. So, so as you can see, I mean, it's nearly impossible to be a water entrepreneur in California. So given the heavy regulation by government of California water management distribution systems, there's a lot of mispricing of water that's kind of cooked or baked into the structure. So as I mentioned, the state runs the State Water Project, and the federal government runs the Central Valley Water Project. These are two massive water collection and distribution systems throughout California. I mean, it is an engineering marvel, but the problem with having government so much in control of these systems is that you get a lot of mispricing and misallocation of water built into these two main water distribution systems because, of course, it's managed and run by governments, so they're responding to political incentives, not economic incentives. So, for example, just one example of how, and Randy touched on this earlier, of how prices can diverge. In a typical non-drought year, the price paid for water by Central Valley farmers, that's the main agricultural area of California, is less than 2% of the price paid by Los Angeles residents for water from the same government project. So farmers are getting it at 2% of what the urban areas are paying. Today's farmers in parts of California are consuming heavily subsidized water at $20 per acre foot that is worth more than $2,000 per acre foot in urban areas. So you see these huge price differentials. If it was a functioning market, of course, I mean, water would be traded from from the low price area to the high price area until you hit an equilibrium given transaction costs and all that. But we don't see that in California because of what I call in the book paper dams. I mean, these are essentially regulations and laws that make it incredibly difficult to transfer water from one parts of the state to others. So I talk about 11 laws that apply to California that inhibit the transfer trade of water in California. And for example, here's a quote from Nancy Kwan. She's with the California Department of Water Resources. So just to back up a little bit, you can trade, but it's incredibly difficult. There's a lot of hoops you have to jump through in order to get the permits and the authorization to do it. So for example, this woman, Nancy Kwan, said, if you're going to use our facilities, this being the State Water Project, to transport the water, you have to show that the sale is going to have no negative impact on the economy or the environment and is not going to injure other water users. So this process usually involves visits from Department of Water Resources scientists to evaluate all of these things. It can take months, if not more than a year. So the water you need in one growing season, well, after the next rainy season, you might not need it anymore, or you might need more of it. So it's such a slow process to get the trade authorized that it can actually span 2 rain seasons. So it makes it incredibly inefficient to try to kind of plan and to structure these. So in other words, in order to trade legally in California, the parties must prove reasonable and beneficial consumption use before trading, verify their trade will not injure any other legitimate water right holder, verify their trade will not harm the environment. So, I mean, it's just a regulatory nightmare to jump through all these hoops. So who does this benefit? I mean, it's the large water agencies. I mean, that's kind of the trades that we do see are limited to the really large companies that can afford the staff and to keep the staff employed full-time to do this type of work. So, so to kind of sum up, the water trades amount to less than 5% of California water usage. So as you can see, I mean, there's very few trades in California above out in the open. So that's not to say, though, again, with any kind of heavily regulated market, you expect to see a lot of under the table type trades going on. And that's what it is going on in California. So I don't want to give you the impression that no trades occur. So these are kind of the official trades are less than 5% of California water use. But we do see a lot of informal trading, especially amongst neighbors. So sometimes, I mean, that usually just involves like lifting a irrigation gate to transfer the water from one neighbor to the other. So you see a lot of informal trading locally. That's very kind of kept on the down low. But these big trades that are involved, like from one part of California to the other, one watershed to the other, really don't occur very often. Less than 5%, as I mentioned, in terms of water use. So the effect of this is that it locks water into historical usages. So whether or not that still is the highest and best use for the water, it tends to remain that use for decades, if not longer, and it may no longer reflect kind of the economic realities of the state. So those are some of the key problems with kind of the distribution side of things. Now, in terms of the other side, the water rights side, California has kind of a very unique system of kind of tiered water rights, and senior rights, junior rights, that sort of thing. And there was a recent study that found that after 100 years, and after 1914, the State Water Resources Control Board issues permits for new water rights. So before that, it was first in use, first in right, but afterwards the government got more involved. But this shows you how poorly they've done. So after the first 100 years of government water rights permitting, this recent study found that the Water Board had handed out rights amounting to more than 5 times the state's actual wet water supply. So one of the lawyers from the Natural Resources Defense Council said, "We are living with a legacy of decades of over-allocating our water and refusing to say no when people want more. So there's more claims to water than actual water to be used. And of course, that situation is ripe for political favoritism and cronyism, which is a lot of what we see. The government also does a really poor job of tracking actual water use. So another quote from the same study, and I can get you, if you give me your email, I can send you the background information and where you can find this study, but the amount of water actually used, this is from this report, the amount of water actually used by water rights holders is poorly tracked and highly uncertain. The state simply does not have accurate knowledge of how much water is being used by most water rights holders. And the Associated Press did a review of the records that are on file with the state of California, and they found that they're incomplete, they're years out of date, they're riddled with errors. For example, a small 300-home retirement community was listed as using more water than Los Angeles or San Francisco in 1 year. The actual water use was 26 acre-feet when they said they were using 8.36 million acre-feet. A small farm in San Luis Obispo was listed as using 875,000 acre-feet for irrigation when in fact it was only using 550 acre-feet. Wintune, which is the lesser-known Hearst Castle, was listed in the state records as using 1.8 million acre-feet, enough water for 7 million people, when actually it was using 448 acre-feet. So, it just shows you how inaccurate the state records are. And again, it's difficult for a market, as Randy was saying, it's difficult for a market to emerge and to be efficient and effective if people don't know what people are really trading and what people have rights in and what people don't have rights in. So the bottom line is, the state is heavily regulated, and so it's difficult to be innovative, but that's exactly what the state needs. And the last chapter of the book that I'm working on currently is going to talk about various innovations and ways that entrepreneurs could enter the market and do things better. Starting out with, of course, fixing the price system. So you recommended, an online water market system, something similar to like WaterFind or something, a high-tech, sophisticated online platform where you could trade water rights or water usage. You could trade water futures on a common exchange, in a commodity type exchange. So that's the first kind of 2 recommendations, is first get the prices right, and then hopefully move on to investments. I think if you make investment decisions when the prices are distorted, you're going to end up probably making decisions that aren't necessary. Or, we saw this with the Great Recession, right? Interest rates distorted the housing market, so you got over investment in construction of housing, malinvestment, as the Austrians would call it, and it's all due to distortions in the price system. So a lot of the infrastructure investments that are talked about in California probably wouldn't be necessary if you just freed up the price side and had the water allocated to its most highly valued use in the right parts of the state. But that said, I mean, I think there's still room for entrepreneurs to enter the market and be successful and develop new and better ways of doing things. And I talk about off-stream reservoirs, private water banking, wastewater recycling, stormwater harvesting, pipelines, desalinization. Again, these things are all that could be done by the private sector. You wouldn't need the government involved necessarily. But again, I think you want to go careful and get the prices right, because I think if you got the prices right, a lot of water would flow from agricultural uses, where in California is probably not the highest and best use of the water, to the cities. So the cities might not have to invest in desal plants that are incredibly expensive, and you might not even want to use them if you're getting sufficient water from the Central Valley, and then that would incent farmers then to invest in more efficient irrigation systems. I mean, flood irrigation is still the most common way of irrigating California, rather than drip or subsoil, that sort of thing. So I think get the prices right first, and then and get entrepreneurs back into the market, and I think they'll figure out better ways of providing water for the state. Thank you.
Thank you, Lawrence. Our fourth panelist speaker is Bryan Ison. He is the research manager at the Center for Growth and Opportunity at Utah State University.
Thanks, David. So the paper that I'm going to be talking about today is a paper that I worked on with Randy. And so it was myself, Randy, and two other master students. So whoops, sneak peek. Two other master students at Utah State University, Grant Patty and Devin Stein. And the reason that we decided to write this paper, kind of what inspired it, is we were looking at water institutions and management in the West a few years back when California was having its major drought. And we were seeing consistent issues throughout a lot of these states. As you'll see after listening to Lawrence talk, Utah suffers from a lot of the same issues that California does. And so we thought it would be a really cool opportunity to actually dive in and look a little bit deeper about what's happening with water in our state, and maybe make some recommendations or find some solutions for some of these problems. So to start off, Utah is the second driest state in the nation, but we are among the highest water users per capita. Typically in an average year, we'll use triple the national average. The national average is around 80 to 100 gallons. Utah, can be upwards of 260 gallons per capita, which, as an economist, when we were getting into this project, we looked at that and we said, there's not a connection there between price and the demand for water, obviously. So the problems that I'm going to talk about, we go into the politics, we go into the economics, and we look at the institutions. Randy talked a lot about the institutions, so I won't really go into that. But the economics and politics have major implications for the state of Utah and taxpayers. So right now, it's predicted that Utah could grow by 1 million residents by the year 2065. And as it stands right now, the Utah Division of Water Resources estimates that we will run out of water by the year 2025. Which, as you heard Lawrence talk about, and for anybody who's ever dealt with government data, their data is typically not really reliable, therefore their forecasts aren't very reliable. They say that if we follow their conservation measures, then luckily that water will get us out to 2050, but after 2050 we're doomed unless, as you'll see, we spend billions of dollars on proposed water infrastructure projects. And that's really the main issue here is these forecasts and emphasis on big spending on water projects creates a real moral hazard in the state of Utah and in the western United States. So we'll skip through institutions since Randy talked about those. Get into the economics. So we wanted to look a little bit about pricing. Why are Utahns using so much water, more than you would assume they would if price reflected demand and scarcity. And what we found is price typically reflects the cost of distribution, and government policies are distorting what consumers see as the price of their water. The reason for this is Utahns, when they get a bill, typically the price they see on their bill only accounts, and this differs between water conservancy districts, but this is pretty typical of more populated districts, like in the Salt Lake, Provo area, kind of along the Wasatch Front. Typically, that number they see on their bill is only 25% of the full cost of the water that they are consuming. As you can see, some of that comes from subsidies, but a large portion of it comes from property taxes, because conservancy districts prefer getting that money from property taxes because it's a steady revenue stream. There's not a lot of variability there. They know they can count on it, but it doesn't send a price signal to consumers to help them understand just how scarce or how valuable the water that they're consuming actually is. They have, kudos to Utah. In 2016, they did try and implement a tiered pricing strategy. The issue with any tiered pricing strategy, so the idea is that at certain levels of use, the cost of your water is going to go up. There may be a really cheap cost to standard amounts of water needed for living. Then, if you want to indulge yourself, water your lawn a few times a week, you're going to end up paying more. If you want a swimming pool, then you're going to pay even more. But the issue is demand for water is actually fairly price inelastic, at least at the prices that are currently charged to water users. So unless you get really extreme with your pricing tiers, you're going to have a hard time curbing a lot of water use. And all of these issues relate to municipal water uses, which is only actually a small fraction of total water use in Utah. So we'll get through this. Just go back one. Agricultural water is actually 82% of developed water use in Utah goes towards agriculture. So that is where a major portion of water use is occurring, but is also where a lot of subsidies fall. And I'm going to talk about the Central Utah Water Project, which is similar to the Central Valley Project in California. The Central Utah Water Project is a Bureau of Reclamation project that started in the state of Utah in the mid-20th century and was built to provide water to farmers and residents. The Bonneville unit is the largest consumer of the Central Utah Project. They developed 313,000 acre feet initially, and the estimated cost of that development was $115 million. In 1985, they realized that they were going to be way over that cap. They increased it to $500 million. And as you can see here, the estimated cost of that project is up to $2 billion at this point for the Bonneville unit. So that's a little foreshadowing of how effective and costly, effective these federal projects can be. I'm going to go into a couple of proposed projects here in a minute that Utah is currently looking at exploring. But the really crazy thing about this is if you look at the actual cost of providing the water that these farmers are using from the Central Utah Project, estimated cost for providing that water is $4,000 per acre foot. Farmers are paying $13 for that same water, which is crazy. It's nuts. So the odds of repaying this project are astronomical. It's really costly to taxpayers, and it's a major bust. It's terrible. It doesn't provide any kind of good market incentive, which is why, looking through that, we're so concerned about current politics in Utah and the direction we're headed. We were looking, kind of using a public choice frame to look at some of these issues. There was a legislative audit in 2015 that looked at the actual data and forecasting that was being used in Utah to predict basically this catastrophic event that we're going to run out of water by 2050. And what they found was that they couldn't replicate, using the data that the Division of Water Resources had, they couldn't replicate the same study and findings that the Division of Water Resources had used to make this prediction that we were going to be running out of water by 2025. And similar to issues in California, they were finding that some of this data, there were cities in Utah who were reporting water use from New York, a city in New York with the same name. They were reporting that water use rather than their own water use. You're making forecasts to basically justify massive multi-billion-dollar projects using data that is completely useless, essentially. So I'll talk real quick, since I don't have a ton of time, just about the two projects that Utah's been exploring lately. The first one is up in northern Utah. It's called the Bear River Development Project. It's a large-scale reservoir project. They're looking at building a couple of reservoirs in the mountains in northern Utah. And currently, the cost estimate for this project is $2 billion to develop the water that they're looking at developing. They recently put this project on hold. So in 1991, that was when they started the project, and they said, we've got to get working on this now because we're going to need it by 2015. Last year in 2017, they said, you know what, we've put this project on hold. We don't actually need it. We thought we would, but we're definitely going to need it by 2040. And I'm willing to bet you that when we hit 2040, it's going to be a similar case of, you know, we don't need it now, but we're going to have it in 2060, so we better push out that proposal. The frustrating thing here is they've spent already over $23 million on this project, just developing it, looking at permits, planning. During that same time, they've spent $4 million on conservation. So that $23 million that was spent on a project that we probably won't ever need is just money down the drain that could have been put towards other more efficient uses. And probably the other more frustrating project that's being explored right now is the infamous Lake Powell pipeline. Okay, this is a pipeline that they're looking at building down in southern Utah, you know, a climate very similar to Las Vegas, desert area. It's a 139-mile pipeline that will run from Lake Powell to Washington County. St. George is the major city in that area that they're looking to provide water for. The initial cost estimates were $250 million for this project. Most recent cost estimates are anywhere between $1.4 and $2.4 billion. But the real frustrating thing about this project is there was a study done by some economists in Utah that looked at, you know, the current water demands in southern Utah. If you just raise the cost of water, it would lower demand enough that this project would never be needed. And the way they're planning on paying for this project is the water districts down there are planning on tripling the cost of the water that they provide to consumers to pay for this project, which they're going to find out once they triple that cost, everybody's going to stop using water and they're not going to need this project in the first place. On top of that, it is, I think there's a 50-year window to pay off the project. Lake Powell isn't necessarily even expected to be around in 50 years because water levels are dropping. So by the time they get this pipeline paid off, their water source for the pipeline might just be totally gone. So I think I'm about out of time. If you're interested in looking at this, there's a whole mess of issues with the permitting. I think they submitted a 6,000-page permit to FERC just recently, earlier this year, and I think they'd only filled out like 9 of the 23 required permits when they submitted it, and they hadn't done the required cost-benefit estimate. So there's a whole mess of issues going on with these projects. So in the paper, we go into a lot of these issues. We talk a lot more about the institutions. If anybody's interested in Utah water, I'd be happy to share the paper with you. I really enjoyed working on it. But we make some recommendations that, if we were able to verify the quality of data being used to project Utah's future water needs and allowed markets to allocate water instead of politics, then water would be able to find its way to its most highly valued uses, and we wouldn't be stuck having taxpayers foot the bills for these multi-billion-dollar projects that in reality are completely unnecessary. So thank you.
So thank you very much for coming.